Welcome to IP Safeguard with Dr. Micro, a concise guide to protecting innovation and creating value. In this session, we will outline practical strategies for recognizing and securing intellectual property, balancing disclosure with exclusivity, and choosing the right protections for your work. Think of this as a roadmap to turning ideas into defensible assets while avoiding common legal and commercial pitfalls. Unprotected IP can be expensive in many ways. Copied products erode sales, costly litigation drains resources, partnerships can break down, and reputational harm undermines future opportunities. The slide's case snapshots show a delayed registration triggering a flood of clones and lost revenue, and a trust-breaking partnership where shared designs were used without consent. The key point is, prevention and early registration are far cheaper than crisis recovery. Patents are a bargain. Public disclosure in exchange for time, limited monopoly rights that drive innovation. To qualify an invention must clear 3 filters: novelty, an inventive step that isn't obvious, and industrial applicability. The typical patent timeline runs from recording the invention and searching prior art to filing, publication around 18 months, prosecution, and ultimately grant, with durations and costs varying by jurisdiction. Trade secrets protect confidential business information by keeping valuable knowledge out of the public domain, but only if it qualifies and reasonable measures are taken. That means need-to-know access, secure storage, and employee NDAs to enforce secrecy. The slide also warns that independent discovery or lawful reverse engineering are valid exceptions, so protecting trade secrets requires both discipline and realistic risk assessment. Copyright gives automatic protection the moment an original work is fixed in a tangible medium, covering literary, artistic, software, and digital content without registration. Owners control reproduction, adaptation, distribution, and public display, but limited exceptions like fair use allow commentary, teaching, and other public benefit uses. Understanding these boundaries helps creators assert rights while allowing legitimate, narrowly defined uses. Trademarks protect signs, names, logos, colors, even sounds that distinguish goods or services, but only distinctive marks register easily. Building and preserving brand equity requires continuous use, timely renewals, and active policing against confusing or misleading marks. The biggest threat is genericide, where a brand name becomes the general term and loses protection. So vigilance and consistent enforcement are essential. A disciplined invention, disclosure, process speeds decisions and preserves rights. Act immediately after a breakthrough by completing a standard disclosure form. Record contributors, experimental data and prior art. Then adhere to an internal submission deadline for prompt processing. Finally, an IP committee reviews and triages each disclosure to evaluate patentability, business value, and recommended next steps. Freedom to operate is a proactive legal safeguard. Conduct comprehensive searches of patents, publications, and trademark registers. Document and analyze the findings to create an auditable record, and use those results to inform strategic choices. By justifying technical investment before heavy spending, teams can modify designs, seek licenses, or abandon risky paths, and minimize infringement shocks down the line. A global IP strategy balances regional filing routes, provisional tactics, and lifecycle management. Choose the appropriate route: USPTO for national focus, EPO for centralized European filings, or WIPO for delayed national phase entry. Then use a 2-stage provisional approach to secure an early priority date and defer costs while testing market viability. Align renewals and trimming of non-core assets with business goals to optimize portfolio value. Small, consistent lab and office habits build a culture of instinctive security. Lock screens when away, clearly label confidential files, restrict cloud sharing to approved encrypted platforms, mark drafts with copyright or proprietary notices, and secure visitor areas with strict access controls. These micro-actions may seem minor individually, but together they make protecting intellectual property a routine part of daily work. Contracts are essential tools for securing IP. Employee assignment, provisions transfer invention rights to the company, NDAs define permissible disclosure and protect confidential information, and joint development agreements allocate ownership and revenue shares for collaborative projects. The practical takeaway is enforceable protection. Starts with papers' secure written signatures before any technical discussion begins to avoid misunderstandings and preserve later rights. To wrap up, focus on a few core habits. Identify and document innovations early, file for protection promptly, clearly mark and protect secrets, train teams on IP protocols, search regularly for potential conflicts, and audit compliance periodically. Use the action template to list your top 3 assets, define immediate protection steps, assign owners, and set completion dates so your most critical IP gets prioritized and tracked.